This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Another copyright troll has lost its case to J. Curtis Edmondson, my co-counsel in Strike 3 Holdings cases from the West Coast. Kurt Edmondson and I have co-counseled up, and I handle the East Coast and he handles the West Coast. I handle litigation on the East Coast, which we're not really doing. We have one going right now. And he handles a bunch of litigation on the West Coast. He loves to fight Strike 3 Holdings. He loves to fight copyright trolls. And he has won this case brought by Hunter Killer Productions against AKA Wireless Inc. This one's really interesting. It has some cool facts about an employer and employees and helping customers get unauthorized copyrighted material on their phones. And the court writes, this action arises from defendants aka Wireless or Victra's alleged promotion of piracy apps to customers and inducing them to infringe upon plaintiff Hunter Killer Productions' copyright in its movie Hunter Killer. For the following reasons, the judge is dismissing the case. This action concerns the purported intentional inducement and contributory copyright infringement committed by defendants' employees. Plaintiff alleges that defendants' employees promoted movie piracy apps at Victra stores for the purpose of infringing its copyright. Plaintiff identifies two employees who engaged in this conduct, Sabrina Boylan from the El Paso, Texas store, and Taylor Wolf from the Kahului, Hawaii store. According to plaintiff, Boylan and Wolf promoted piracy apps to encourage customers to purchase devices, then installed piracy apps such as Popcorn Time and Showbox on the devices and instructed customers how to use the apps to watch free movies. Boylan allegedly enticed Gerard Prado to purchase a Samsung Galaxy tablet with the promise of free movies and installed Popcorn Time on the device at the El Paso store. Prado subsequently used Popcorn Time to download all or a portion of Hunter Killer while he was in Hawaii. Wolf reportedly encouraged Cassandra Pocchini to purchase a new phone or service by offering Pocchini a free tablet and informing Pocchini that she could use the tablet to watch free movies. After Pocchini completed the purchase, Wolf installed the Showbox app on the tablet at the Kahului store and showed Pocchini and her husband how to watch movies. The Pocchinis then used Showbox to download copies of copyrighted protected content. Plaintiff does not allege what content the Pocchinis downloaded nor when it was downloaded. Plaintiff alleges that defendants knew that their employees were promoting and distributing piracy apps to customers due to allegations against Wolf in prior litigation. Plaintiff further claims that Boyles and Wolf's conduct fell within the scope of their employment and that Victra benefited from said conduct and is therefore the employer is liable. So I'm going to skip the procedural history and get straight to the legal standard. The Federal Rule of Civil Procedure 12b-6, the motion to dismiss, authorizes dismissal of a complaint that fails to state a claim upon which relief can be granted. On such a motion to dismiss, the court accepts the facts alleged in the complaint as true, and dismissal can be based on the lack of cognizable legal theory or the absence of sufficient facts. However, conclusory allegations of law, unwarranted deductions from fact, and unreasonable inferences are insufficient to defeat a motion to dismiss. Furthermore, the court need not accept as true allegations that contradict matters properly subject to judicial notice. So in other words, if the court can bring in its own evidence that it's found out about, that it's on proper judicial notice for, then the court can take that in too, and doesn't have to treat allegations as true or false based on the motion to dismiss alone. Defendants argue that they cannot be liable as a retailer for their employees' promotion of piracy apps under contributory infringement or vicarious infringement. The Supreme Court has identified contributory infringement and vicarious infringement as two categories of secondary copyright infringement. One infringes contributorily by intentionally inducing or encouraging direct infringement, and infringes vicariously by profiting from direct infringement while declining to exercise a right to stop or limit it. The Copyright Act does not expressly impose liability for infringement committed by another, but these secondary liability doctrines emerged from common law principles that are well established. For secondary liability to attach, a plaintiff must establish direct infringement by third parties. Secondary liability for copyright infringement does not exist in the absence of direct infringement by a third party. To establish direct copyright infringement, a plaintiff must show that he owns the copyright and that the defendant himself violated one or more of the plaintiff's exclusive rights under the Copyright Act. A plaintiff must additionally show causation, volitional conduct, by the defendant. In the factual background section of the first amended complaint, plaintiff alleges that Prado downloaded at least a portion of Hunter Killer using popcorn time on the tablet purchased at the El Paso Victra store. Within the intentional inducement claim, plaintiff alleges that piracy apps connect users to sources publicly performing or distributing Hunter Killer, and the operators of those sources directly infringe plaintiff's copyright by streaming and or providing copies of Hunter Killer to the public, including customers like Prado. Plaintiff also alleges that the Pokinis used Showbox to download copies of copyrighted protected content. However, plaintiff does not allege that the Pokinis violated its copyright with respect to Hunter Killer. And at the hearing, plaintiff's counsel confirmed that the Pokinis did not download Hunter Killer, but nevertheless insisted that plaintiff could premise liability on Pokini's general infringing conduct. The court rejects plaintiff's contention that it can base claims on conduct not involving its exclusive rights, as contributory infringement is predicated on underlying direct infringement. Direct infringement requires a violation of plaintiff's exclusive copyright, and under a theory of inducement liability, causation requires that the product or service at issue was used to infringe the plaintiff's copyrights. Consequently, plaintiff's secondary copyright infringement claims cannot rest on allegations related to the Pokinis. Plaintiff asserts an intentional inducement claim and a contributory infringement claim. Contributory infringement occurs when a defendant intentionally induces or encourages direct infringement. The Supreme Court has defined two categories of contributory liability. Liability may be predicated on actively encouraging or inducing infringement through specific acts, or on distributing a product distributees use to infringe copyrights, if the product is not capable of substantial or commercially significant non-infringing uses. Contributory liability requires that a party 1 has knowledge of another's infringement, 2 either A materially contributes or B induces that infringement. Plaintiff only alleges that defendants had actual or constructive knowledge of third parties' infringements of plaintiff's exclusive rights with respect to its contributory copyright infringement claim. The knowledge prong requires more than a generalized knowledge by defendants of the possibility of infringement. Contributory infringement liability requires actual knowledge of specific facts of infringement. Plaintiff's generalized allegation that defendants had active or constructive knowledge of customers' infringement is insufficient. For this reason alone, plaintiff's intentional inducement and contributory copyright infringement claims should be dismissed. But even if plaintiff adequately pled knowledge, the court would dismiss the claims. Defendants argue that plaintiff's intentional inducement claim must be dismissed because it is not a cause of action and or is duplicative of plaintiff's contributory infringement claim. Plaintiff posits that Metro-Goldwyn-Mayer Studios versus Grokster created intentional inducement as a basis for secondary copyright infringement that is distinct from contributory infringement or vicarious infringement. While Grokster concerned an inducement theory, the Supreme Court did not recognize it as an additional secondary copyright infringement cause of action. Instead, it addressed inducement as a subset of contributory infringement. The Ninth Circuit has similarly identified intentional inducement as a theory of contributory infringement liability with material contribution as the other. The inducement theory has 4 elements. 1, the distribution of a device or product. 2, acts of infringement. 3, an object of promoting its use to infringe copyright. And 4, causation. Under an inducement theory, one who distributes a device with the object of promoting its use to infringe copyright, as shown by clear expression or other affirmative steps taken to foster infringement, is liable for the resulting acts of infringement by third parties. It premises liability on purposeful, culpable expression and conduct, not mere knowledge of infringing potential or of actual infringing uses or ordinary acts incident to product distribution. Affirmative steps taken to encourage direct infringement include advertising an infringing use or instructing how to engage in an infringing use, as they show an affirmative intent that the product be used to infringe. Plaintiff alleges that defendants intentionally induced the infringement of plaintiff's exclusive rights, as intended and encouraged, popcorn time connects to sources, etc. Defendants induced There's no facts here, really, besides that they accuse them of using popcorn time. As noted above, plaintiff failed to allege that defendants had knowledge of Prato's infringement, which is a necessary element of contributory liability. Plaintiff therefore fails to state a claim for contributory copyright infringement by inducement. Assuming plaintiff alleged that defendants had the requisite knowledge, its allegations regarding inducement are nevertheless deficient. Plaintiff's claims that defendants' employees installed piracy apps on devices sold to customers, and those apps created direct links between said customers and infringing sources that provide streams and/or copies of copyrighted works. As pled, plaintiff has not sufficiently alleged that defendants intended, through the purported installation of those piracy apps on devices it sold, for the devices to be used to infringe plaintiff's copyright in Hunter Killer. Accordingly, the court dismisses plaintiff's intentional inducement claim. Because amendment could potentially cure the foregoing defects, the court will grant leave to amend. Plaintiff's contributory copyright infringement claim count 2 is founded on a material contribution theory. Material contribution turns on whether the activity in question substantially assists direct infringement. Plaintiff alleges in pertinent part that defendants had actual knowledge and continued to promote and distribute piracy apps. Defendants knowingly and materially contribute to infringing activity, such as that of employee Prato. Defendants' knowing and material contribution to the infringement is willful, and that defendants' actions are a direct and proximate cause of the infringements of plaintiff's work. These allegations do little more than recite the elements of a contributory copyright infringement claim. Plaintiff's factual background section of the First Amended complaint includes certain facts that might bolster this claim, but plaintiff has not included those specific facts and allegations within the claim. It is not the court's responsibility to piece together plaintiff's factual and legal allegations scattered throughout the First Amended complaint to ascertain whether, when taken together, they sufficiently state a claim. For these reasons, plaintiff's contributory copyright infringement claim, count 2, is dismissed. The court grants leave to amend. Plaintiff's final claim seeks to impose respondeat superior liability upon defendants for their employees' contributory copyright infringement. This is the employer being responsible for the acts of the employee. The plaintiff writes, Boyling's and Wolf's intentional inducement and contributory infringement occurred within the scope of their employment, therefore, defendant is liable. Their inducement and infringement occurred within the scope of their employment to ABC, therefore ABC is liable. This claim fails on multiple grounds. First, notwithstanding plaintiff's criticism of defendants for characterizing this claim as one for vicarious infringement, defendants are correct that allegations of this nature are normally pled as a vicarious infringement claim. Indeed, vicarious infringement's roots lie in the agency principles of respondeat superior, while contributory infringement is based on tort law principles of enterprise liability and imputed intent. To the extent plaintiff seeks to impose liability based on a respondeat superior theory other than vicarious infringement, it has not identified the legal authority for such a claim. Respondeat superior liability is a state and common law concept, and counsel admitted this at the hearing. Yet plaintiff's bases for jurisdiction are 28 U.S.C. 1331 and 1338, without any jurisdictional allegations that would authorize the inclusion of this state law claim. So they've only alleged that you have personal jurisdiction and copyright federal jurisdiction. Second, a respondeat superior liability claim is duplicative of counts 1 and 2. Plaintiff's contributory infringement claim against defendants, improperly pled as two separate counts of contributory infringement and intentional inducement, is premised on defendants' employees' conduct. But because plaintiff does not name any employees as defendants, it effectively seeks to twice impose liability against defendants based on the same underlying facts. One for contributory infringement and intentional inducement, and again for respondeat superior liability for contributory infringement and intentional inducement. At the hearing, plaintiff's counsel conceded that this is not technically a separate claim, but was pled in this manner to highlight the fact that the allegations against defendants are for their employees' conduct. Third, the allegations against Wolf are improper because they pertain to infringement by the Pokinis, and as stated above, plaintiff did not, and as it conceded cannot, assert that the Pokinis downloaded Hunter Killer. A claim cannot be predicated on conduct having no relationship to the plaintiff. For these reasons, the court dismisses plaintiff's respondeat superior claim. The court declines to authorize amendment because of plaintiff's counsel's admission that this was not properly asserted. Plaintiff's deadline to file the second amended complaint is August 10th. Any amended pleading must address the deficiencies identified herein. Given the dismissal of the first amended complaint, plaintiff's motion for a preliminary injunction is moot, and the judge is also not going to transfer venue. And so the case is dismissed with leave to amend, and that is Judge Jill A. Otaka from Honolulu, Hawaii on July 17th. So that is a really remarkable opinion. Seems to me that Hunter Killer just didn't do its homework. They might have been able to nail the business, which would, deep pockets, right? If you sue an individual, well, half the individuals in the states don't have any money, and the other half are going to fight you. So you might want to sue the company. They have bigger pockets. They have deeper pockets. They have more money. They have corporate lawyers, et cetera, et cetera, et cetera. Well, no. They hired Curtis Edmondson, and Curtis Edmondson just simply made plaintiff prove their case, and plaintiff couldn't prove their case, couldn't even begin to prove their case past a motion to dismiss, which is a little pathetic. Given the nature of this allegation, there should have been more due diligence done by the filing attorneys. So yeah, I'm going to go and say that that's not correct. You shouldn't have filed this case without having first gone through all of these theories and presented it properly, because it wasn't presented. It looked like 4 or 5 counts were filed when it was 2, vicarious and contributory. And instead they did vicarious, contributory, they did the material contribution and the inducement, and then they did the respondeat superior, so that's 5. So yeah, it was basically improperly written and filed. Maybe after being amended, the plaintiff will be able to make out more of their claims. I doubt it, but, we've seen plaintiffs make some strange decisions, so I'm not going to try and predict this one. Sorry. Let us know what you think in the comments below. So that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal education and legal news channel here on YouTube, Floatplane, and Twitch. Thank you in the month of July to the following supporters on patreon.com/ljfrench and sponsus.org/law. We also include the YouTube members and Floatplane members in this as best we can. Special thanks to BU1 Simmons in the month of July. Thank you very much for your support. And thank you to the July $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, HotGrillsInYourArea, Ameknight, and Brandon Abel. And thank you to the July $5 plus supporters. I wasn't able to bring the LED Matrix panel with me, but we're going to find a way to get one and make one for our show here. I really don't want to do just a generic monitor. I want it to be something cool and technical, like a LED panel. So thank you to all of the $5 plus supporters who are scrolling in front of me on the crawl. Everyone's going to be in the descriptions of the videos that drop. I'm Leonard French, your favorite copyright attorney. I will see you in the videos this week. I love you all. Bye.
I'm torn up like some pieces of the paper. Don't burn up in the morning, let it taper. Inhale and let it out like reservations. Exhale and breathe, I'm praying for some patience. Proceed, I think I might